when you have someone like Brennan making prior statements, which frankly seemed to be unsupported and not in the form of an affidavit to the court about, well, these files were kept in these folders, and then it's in an iCloud of a retired detective, and then it's suddenly there's new videos that have been produced, why these weren't erased or auto erased on the every 30-day kind of time period that he also told the court, but new videos have come out. Like, you need a roadmap to try to keep tabs on all of this stuff.
It wasn't lip service. It wasn't trying to spin a story for the media. It was a good faith effort to accommodate the defense to an entitlement that they weren't actually entitled to.
Just got home. TLDR. The TLDR can be summed up in little bumpers. So first,
conspiracy.
And then, and last but not least, what was so special about this video that caused the officer to download it? And if it was that special, why didn't they officially preserve it?
He said when he would download it, he then had his own hard drive at his office, and there was different files. One was called detective file because he's a detective. And he'd simply click and drag a copy of whatever he filed or copied for the government or the state police before. It wasn't a full accounting of all the metadata or all the video. It was whatever he decided to copy because he was asked to copy it.
They knew it was special enough to download, and they also knew it was special enough to tuck away in a file and never tell anyone about. Like,
There's nothing mysterious about it. There's no hiding about it. There's no story. It's just video on the detective file on his hard drive.
So, in terms of whether the prosecution's disclosure was sufficiently timely to allow them to make effective use of the evidence in preparing and presenting the case, the preparing and presenting all happened, and then the disclosure. So, unless you're alleging that the defense counsel has access to a fucking time machine,
Technically, we don't have any other obligation other than to download it. It seems as though when I extend courtesies and obligations, it becomes complicated. It's not a complicated process.
Mr. Brennan went to the Canton Police Department and found out that there was, in fact, additional video, which was news to us. He claims that it was news to him. And putting aside how odd that is, after 3 years of being told we have everything, he went on to explain in very specific form in a telephone conversation that he had met with a retired detective. At the time, he could not remember the detective's name. He said the detective believed that he kept a copy of the January 29 video that we were looking for, and that he said that it was on a work computer's iCloud account. After we reached this agreement that the iCloud would just be downloaded and videoed, we received an email from Ms. McLaughlin.
And when I met with the chief and other officers, I was told by a retired sergeant who was there, DGM Petro, that he was the officer who would download video upon request. Never downloaded a 24-hour period. He was never asked to. There was never a motion to. When the government would ask, or state police would ask for a download of a particular event, like the Sallyport area, he would download it. What he told me is that that is on the DVR, an independent unit that has all the metadata and the logs if it still survives time.
Their analyst actually called Mr. Brennan when our expert, who was on the floor at Canton PD, asked, are there any original files that are in the possession of Canton PD? The analyst went, I think her name was Colleen Crawford. It was Colleen Crawford. She went and called Mr. Brennan, according to our analyst. Mr. Brennan then informed Ms. Crawford to tell our expert, get it from the defense. Whatever, if you want original files, get it from the defense, knowing full well that we don't have it. If we had it, we wouldn't be there. And then it was that same day that miraculously the Canton Police Department revealed that in fact it did have some video footage on this either iCloud or video system. Did you obtain a copy of any video surveillance footage from Canton Police Department?
Yes.
Did you give that video to Trooper Proctor?
I believe I gave it to Sergeant Buchanan.
Sergeant Buchanan? And then what did Sergeant Buchanan do with it?
Reviewed it.
Trooper Proctor, you were notified.
I am not Trooper Proctor.
I'm sorry. No, you're not. Sergeant Buchanan.
Sergeant Buchanan.
How do I say it?
Trooper Bukaki? Bukaki?
Buchanan.
Bukaki?
It appears that there is movement, but the video speaks for itself.
Did Chief Rafferty give it to you on a thumb drive or a disc, or how was it physically provided?
I don't know. I didn't receive it. She dropped it off at the office. I remember a thumb drive.
You remember a thumb drive. All right. And then it's uploaded onto the system, and the case officer would have access to that system.
Yes.
Okay. And in this case, that would be Trooper Proctor.
Yes.
The Commonwealth has produced evidence that since January 2022, the Sallyport camera was replaced due to its defective condition.
But it certainly shows some bias. I've turned over a lot less in this case. Shh. Don't tell them.
Brian Tully sent prosecution team members an email stating, "I spoke with Chief Rafferty. She reviewed the video of the SUV arriving at CPD exists, and we should have it, contrary to what defense represented on Friday. She's putting it on a thumb drive for us in the event we don't have it." Okay.
Tonight, Canton's police chief has issued a statement. In mid-February, she struck a pedestrian in Wrentham and has been cited by police.
More than 6 weeks after a pedestrian was struck and injured in a Wrentham crosswalk, we're learning the driver was Canton Police Chief Helena Rafferty. A police report states the chief was driving down South Street in her town-issued SUV around 6:30 p.m. on February 16th and began to turn onto Creek Street when she hit the 67-year-old man who was wearing a yellow reflective vest and was walking with a cane. Chief Rafferty requested a breathalyzer which showed no trace of alcohol and was issued a civil citation for failing to yield to a pedestrian in a crosswalk. Rafferty explained in a statement, "As I proceeded to make the left turn onto Creek Street, the vehicle lights caught the reflective vest of a person in the crosswalk. I immediately applied my brakes, but unfortunately the car made contact with him, knocking him to the ground."
Shh. Don't tell them.
Adam Lally, are you confident that Karen Reid will be declared not guilty?
Up, or are you just a useless government stooge?
Do you see the verdict coming in tomorrow as not guilty for Karen Reid, Adam Lally? Any comments, sir?
Mr. Lally.
Any comments, sir? All right, thank you so much.
Why are you lying about Jen McCabe's kids not being in that photo with Michael Proctor? It's clearly them, Mr. Lally. Are you in on the cover-up? Are you worried about going to jail? Mr. Lally, you should be.
Because I wanted to know more about the cameras. I had never visited the station. I wanted to know about the process, and I wanted to ask firsthand anybody that was there about the process because I wanted to do due diligence.
And that changed the parameters of what we had believed and what we'd been told by Mr. Brennan, and it sounded more like this. The Commonwealth changed the story from some work computer iCloud account to the footage was being stored on what's called the, quote, department's video file system. It's very different than a retired detective's work computer's iCloud, which is what Mr. Brennan believed at the time and what we were led to believe at the time. So we asked for clarification. Ms. Little sent an email saying, "I'm confused. Now you're talking about something that looks like a much more formal system called the department's, the CPD video file system. So we want, that's fine, no problem, download the videos, but we want the metadata and the log files that are associated with that. If it's on a formal file system, it's going to have metadata for the upload, for any access to the data, and for the download. We want the metadata and the log files as well. And that's the key entirely to the audit trail that we're interested in. Historically, we have been asking for videos, for all this video surveillance to be preserved and provided for about 3 years, and this has been one of the centerpieces of this litigation. When we asked for that additional metadata and the log files, Mr. Brennan, in my opinion, took an odd position, which is, nope, we had an agreement. We met right back there in that room. We said that you could videotape the download of the videos. You don't get anything else. If you want anything else, go to court and file a motion, which is why we had to file this motion. We don't think that it was necessary. This is metadata that is literally in the Commonwealth's possession as we speak. They have it. We're entitled to it. It's simple. That's all we're asking for.
That's not trial by ambush. That's getting duped.
Mr. Brennan referred to the video files being placed on Canton Police Department detective file, which is yet another name for where this mysterious video may be held.
They create illusions and shields and say something's there and something's happening, a federal investigation and this person, and then this happens.
We've been demanding that footage from 2022, January 29th, 2022. We were told explicitly on December 12th that no footage existed when we went out and had an expert look at the DVR.
But I care that it's unfair, imbalanced, and hidden. And the Commonwealth, like the defense, is entitled to discovery.
We take the position very clearly that this is Brady information, it's exculpatory information. The audit trail is also Brady and exculpatory because the audit trail will tell us information that we won't otherwise have from the raw video. How did the footage end up on the system? When did the footage end up on the system? Who put it on the system? How many times has it been accessed? Has it been accessed at all? Has it been altered? Has it been manipulated? Has anything been deleted? Those are all data points that will be embedded in the metadata and the log files. The only way to answer those questions is for us to get it. That's all. And that's all we were asking of Mr. Brennan. We are surprised that he would object to that because we would think that in point of fact, he would want those same data as well. Mr. Brennan made a point of saying, when he first came on this case, look, we want to give Ms. Reed a fair trial. We want to be as transparent as possible. And my hope is that was not just lip service for the media. I don't know why the Commonwealth would object to this. There's no reason to object to it. They have it. We want it. And now we're asking for the court to order it. I'll submit.
It seems like another effort to portray some type of injustice wrought upon the defense that half the facts are left out of the presentation. So to talk about reality, the reality is after they filed a motion making representations that weren't accurate, I no longer have the confidence to have off-the-record agreements with the defense. There has to be a certain level of confidence that when you have an agreement and you try to help the other side, that the memory of the discussion is going to be portrayed accurately.
Well, you know, we expect our criminals to commit crimes. That's what criminals do. We don't expect that from our law enforcement. And so having a very unique opportunity, Jake Carney and I had the ability and the invitation to do anything we could to try to help find the truth and expose what the government had done. And the government had done a number of things that we don't expect from our government. They not only created victims, but they continued to victimize the victims by denying their responsibility.
This will be the first statement of its kind in my dozen years as Norfolk District Attorney. The harassment of witnesses in the murder prosecution of Karen Reed is absolutely baseless. It should be an outrage to any decent person, and it needs to stop. Innuendo is not evidence. False narratives are not evidence. However, what evidence does show is that John O'Keefe never entered the home at 34 Fairview Road in Canton the night he died. Location data from his phone, recovered from the lawn beneath his body when he was transported to the hospital, shows that this phone did not enter that home. 11 people have given statements that they did not see John O'Keefe enter the home at 34 Fairview that night. 0 people have said that they saw him enter the home. 0. No one. Some have, without any evidence, pointed to 18-year-old Colin Albert, a nephew of the homeowner, and accused him of attacking John O'Keefe as he entered the home. but phone evidence shows O'Keefe never entered the home at all. Testimony from witnesses tell us that 18-year-old Colin Albert had left his uncle's home before John O'Keefe and Karen Reed had arrived outside the residence. There was no fight inside that home. John O'Keefe did not enter the home. Colin Albert, the young man being vilified, was not present when Reed's vehicle and John O'Keefe arrived on the street. This is a false narrative. Colin Albert didn't commit murder. Jennifer McCabe, Matthew McCabe, and Brian Albert. These people were not part of a conspiracy and certainly did not commit murder or any crime that night. They have been forthcoming with authority, providing statements, and have not engaged in any cover-up. They are not suspects in any crime. They are merely witnesses in the case. To have them accused of murder is outrageous. To have them harassed and intimidated based on false narratives and accusations is wrong. They are witnesses doing what our justice system asks of them. The autopsy of John O'Keefe was conducted by a forensic pathologist from the Office of the Chief Medical Examiner. The doctor found that the injuries that left John helpless in the cold were not a result of a fight. She further found that the line of abrasions on his arm was consistent with blunt trauma, not an animal attack. A grand jury of everyday citizens heard the documented evidence and testimony before making a decision. The subject of that murder indictment enjoys the constitutional presumption of innocence. Why should the witnesses who have committed no crime be afforded less by members of the community? They should not be harassed for telling the government what they heard or saw. I'm asking the Canton community and everyone who feels invested in this case to hear all the actual evidence at trial before assigning guilt to people who have done nothing wrong. And certainly before taking it upon yourself to harass citizens who evidence shows have done nothing in this matter but come forward and bear witness. We try people in the court and not on the internet for a reason. The internet has no rules of evidence. The internet has no punishment for perjury. And the internet does not know all the facts. Conspiracy theories are not evidence. The idea that multiple police department, EMTs, fire personnel, the medical examiner, and prosecuting agencies are joined in or taken in by a vast conspiracy should be seen for what it is, completely contrary to the evidence and a desperate attempt to reassign guilt. Michael Proctor, the state police trooper, being accused of planting evidence outside 34 Fairview Road, was never at Fairview Road on the day of the incident. Proctor and his state police partner traveled together the entire day while other officers were processing 34 Fairview. Trooper Proctor was not there and did not plant evidence at 34 Fairview Road. In addition to having no opportunity to plant the evidence, as has been suggested, Proctor would have no motive to do so. Trooper Proctor had no close personal relationship with any of the parties involved in the investigation and had no conflict. And he had no reason to step out of this investigation. Every suggestion to the contrary is a lie. This should be seen for what it is and not used as a pretext to attack and harass others. What is happening to the witnesses, some with no actual involvement in the case, is wrong. It is contrary to the American values of fairness and the constitutional value of a fair trial. It needs to stop now. I am releasing this recorded statement rather than holding a news conference because my remarks need to be so narrowly tailored to the issue at hand while the prosecution is pending in Superior Court. But the message is the same. What is happening to these innocent people, these witnesses, is wrong and it needs to stop.
What is back in session? You may be seated.
22117.
All right, so why are we out here?
Your Honor, I just saw the verdict forms, and as we discussed yesterday, the amendments that the court indicated it would make on the verdict
Oh, no. Okay, I did not say I'd make it. I said I'd think about it. I said I was tired and I needed to think about it.
What you said before you were tired and you needed to think about it was you agreed that there needs to be not guilty options for the subordinate charges under count 2.
I said that it made sense to me, but no, I did not change it upon looking at it because the verdict slip, this verdict slip as submitted to the jury, is exactly how it always is in Massachusetts.
Can I ask you a question then? I don't really care how it always is in Massachusetts. I care about whether or not it's appropriate.
It's appropriate.
Different things.
It's appropriate.
Let me make my argument, if you wouldn't mind, Judge, why it's not appropriate. For a superior charge, they have to decide that she is not guilty of the superior charge, and that is the starting point of whether or not she is guilty or not guilty of any subordinate charge, often called a lesser included. Once they decide that she's not guilty of the superior charge, now there's two additional charges that they've been instructed they must decide whether she's guilty or not guilty of. How do they decide that she's not guilty of the first subordinate charge, involuntary manslaughter?
Okay. Anything else you want to say, Mr. Jackson?
I'd like an answer from the court. How do they decide that she's not guilty of involuntary manslaughter on that verdict form?
That's their decision to make.
And how do they make it if they don't have an option to check a box that says not guilty?
They don't check the box that says guilty, do they? And then when they go to the next block, they don't check the block that says guilty, and on the top, you're left with not guilty. Okay?
So it's the absence of the check mark that the court determines is the not guilty finding by the jury.
Yes, that's what the verdict slip reads. It reads not guilty. If they don't check block 2, 3, or 4, the verdict slip reads not guilty. Okay? That's how it is, Mr. Jackson.
Well, and apparently that's how it's going to be because of the court's order. That is not how it should be, and it's over our strong objection. They need to see that there is a not guilty option for the subordinate charges. If they come back guilty on, for instance, involuntary manslaughter, that's immediately appealable. They didn't have an option on the verdict form to find her not guilty. It's almost like the court is directing a verdict of the subordinate charges.
Okay. I disagree with you. Ms. Tianetti, you've seen verdict slips exactly like this. Okay?
I actually haven't really.
Have you had no lesser includeds?
No, we've always had lesser includeds, but I have not seen a verdict slip there where not guilty is not an option for lesser includeds.
Okay. I disagree with you. All right. Excuse me. This is funny, Ms. Reed? All right. We're done.
All rise for the court, please.